True crimers, welcome to Break the Case. You can see off to my left or right, depending on your vantage point, I have Mark Geragos here. And listen, we only have him for about 20 minutes, so we are going to jump right into this. Mark, welcome to the show.
Thank you. It's so good to be here. And we were joking a little bit before. Usually when we're on the right, left, or left, right, depending on how it is, we're at opposite ends of the spectrum, but I'm delighted to be here.
Well, great. Well, the last time I saw you was you and Tenny in studio, and specifically it was at the very beginning of Diddy. So I just have a couple of Diddy questions for you. First of all, unbelievable. All the top charges he was found not guilty of, found guilty of 2 Mann Act charges. This is my question for you. Prosecutors originally were looking at 5 to 6 years. I know the defense were hoping for about 2 years. My question to you is, where do you think that's going to land with all that relevant conduct that this judge has seen?
You know, it's interesting you say that because you're absolutely right. When he was acquitted on the 3 counts, on that day, they made another bail application, and which the judge denied. And they had taken the position, the defense had, that his sentencing guidelines were 21 through 27. In federal court, the guidelines are advisory now, but judges generally hover around the heartland of the guidelines. At that point, Maureen Comey, who was still the lead lawyer at that point for the government, she's since been fired, she was saying somewhere between, as you said, 4 to 5 years, something in there, 60 months, 51 to 60 months, in that range. Since then, they've said they may ask for more. The judge did an interesting thing. He issued an order where he said he wanted both sides to give him other cases in which people were similarly situated and what they had received in terms of a sentence. That tells me, because if you look at it, nobody has ever gotten anywhere over 2 years or 24 months, basically, for Mann Act charges. And the interesting thing is, in this case, this is one of the only times I've ever seen, at least anecdotally, somebody is being prosecuted for the Mann Act for having a prostitute, in this case, males, cross state lines and not have sex with them. So that's an interesting twist. I think that tells you the judge may not be buying what the government is selling, in my humble opinion.
Yeah, Mark, I find it interesting because when they came back and asked for this bail until I think October 3rd, around there is the sentencing, I was absolutely shocked that the judge did not give that bail, particularly with all the allowances the team was going to make, Diddy's team was going to make. So in light of that, I kind of take that as he's taken a pretty hard stance. I mean, if he were only going to get 2 years, I just doubt that he wouldn't give bond or bail. But,
it's interesting. There's a legal argument that he couldn't get around if you, and they've tried it 3 times. The legal argument is that even though the Mann Act, there were no findings. In fact, all the findings of violence were rejected by the jury. The Mann Act does not have any violence connected with it in what was presented to the jury. However, the code section under the 18 USC, the code sections themselves are under a catch-all for violence. And when you have that catch-all for violence, then absent exceptional circumstances, you can't release them on bail. And that's what the judge said. He also went out of his way twice now, I believe, to say this should not be interpreted as having some influence on how I'm going to sentence. And I think that's one of the reasons that he asked them. He said, give me some examples of other cases where people have gotten this kind of time.
All right. So really quick, you and I'm going to say he gets 5 years. What's your best guess?
20 to 24 months, somewhere in there. I don't think he gets more than 24. But one more thing, even if the judge goes up to 36 to 39 months, he will be eligible for what's called RDAP, or First Step, and he will not do anywhere near that amount of time.
All right. We're going to move on because we are on a really tight schedule. Ghislaine Maxwell, I have a couple of questions there for you. First of
And
all,
I got one question for you.
yeah.
Well, what's your take on her being transferred from, I believe it was Tallahassee, to Texas and the camp? What's your take on that?
Oh, it was an absolute quid pro quo. That was something that she came to the table with, and that's what she wanted, at least in the interim, to see what else she could get. But this is often something we put on the table. We put commissary on the table, and we put transfers on the table. That's sort of the first bartering chips we use. And look, she is literally in Club Fed. I know that facility. It's right outside of Bryan, Texas, and they're even. She tried to get a service dog. They even have service dogs for inmates there. So
is this facility, I'm glad you're on. I'm going to ask you can educate me. Is this different than Carswell?
yes.
Okay. So Carswell's the medical facility in Texas. This is a camp.
Yeah, it's pretty much a camp. In fact, I was talking to one of my fellow agents that we were agents together, and he lives right over there. He said he's not even sure they have a fence line.
I don't think they do. I had read that there was no fence, and it's one of the honor yards where, but by the way, nobody tries to escape because God knows you'll get put back and put somewhere where it'd be infinitely worse.
Yeah, like, alligator Alcatraz or whatever they call that.
Right, exactly. And by the way, it's so interesting you say that because I tell people all the time, this is when they want the information. This is what law enforcement does. And people look at me like I'm smoking something when I tell them that.
Oh, no, this was absolutely one of the bartering chips. But my question is, and this agent and I actually had it out because I think this is ridiculous. She's been in 5 years. She's got 15 more to serve. I mean, her actions were egregious. It's basically the head of the organization or the number two. Everybody wants the list of the Johns. They want her to come out and say who was over there doing what with who, whether it was the Virgin Islands, New York, Miami, Florida. So my question to you is, what in the world is going on that she's even getting a bite at this apple?
Well, I think obviously, it's interesting because has some relevance to, I think, one or two of the other cases you're going to talk to me about. But we live in a different era than we did maybe 10 years ago or 20 years ago. And let me kind of just do a little intro to that. With Menendez, the Menendez brothers, who I represent, Leslie Abramson, who was their lawyer 30 years ago, she was fond of saying 10 years or 15 years ago, no amount of TikTok, no amount of public pressure is ever going to change the fact or help them get out. I think that is a parochial view. I think that's just not true. The public, starting with some of the, like you'll remember Serial, where Adnan said, and Making of a Murderer and things like that. We've reached the point, and you do true crime, so you understand it as well. Public transparency, public interest has and rightfully so, that's why we have a First Amendment, has a impact on a lot of these cases. And it's only going to be more so as we go forward. So I understand that they want as you say, they want something. When the DOJ wants something, they've got a lot of chips. I'm old enough to remember when I started practicing, there was what was called a Rule 35. You could be sentenced, you could be sitting in custody, and you could then say, hey, judge, I've done something great, resentence me. They outlawed that in the 90s. Now, the U.S. attorney can come in. If they want, they can dangle a Rule 35. And I've had a number of clients who received that after the fact, years later, and have gotten some kind of benefit when they need you. This is not that unusual in my experience, even in a pre-TikTok era, but in a post-TikTok and post-true crime era, it's even more prevalent. So it's not that unusual. I think she's got information that they want, even to the point where she can debunk things, and I think she probably has, and that may be helpful to them.
Yeah, I find it interesting though with her, Mark, because remember she had those two big perjury charges hanging over her head. And the only reason she didn't go to trial with those was because she already got this big sentence. So they agreed to drop it. So I'm just saying, from a credibility standpoint, she's been on record lying. And I just don't think she's credible at all. I don't know how she can be believed.
Okay, now you can answer. Once again, I'm going to throw a question back to you. One of the things that struck me, and I've been doing this for, I hate to say it, my 5th decade. I've never understood, and it's one of the reasons I think I've had a fair amount of success in federal court. I've never understood the difference between state court cases and federal court cases to this extent. Virtually every federal trial I've ever had, criminal trial, the prosecutor, U.S. attorney, has put on some witness who is a lying piece of garbage, who is now cooperating, who's on his 5th, 6th, in some cases 10th iteration of their story. But now they want the jury to believe that they found religion, so to speak, and they're telling you the truth. It's one of the hallmarks. My father, who was my partner for many years before he passed, used to say the government never brings a case unless they got a wiretap or a snitch. And in federal court. And I've never understood why in the federal system prosecutors embrace people who are demonstrable liars, but they do. And I've made a living off of it, basically.
Well, as long as they don't have a crime of moral turpitude, right, that they've been convicted of, that's where their line is, that the Bureau and prosecutors seem to make their line. And here, I guess, because they're saying she doesn't have a conviction because they dropped the charges when she was convicted of the bigger charges. I mean, I don't know, Mark. You have to have corroboration. And I was thinking, I don't even know how they're going to be able to corroborate half of what she says. So old, witnesses are dead. You have issues with the travel logs in a lot of instances because it was his private planes. I mean, there's so many issues to me with proving anything she says one way or the other. So I'm disappointed that they're even going after her. We're in the same court, I think, on this one.
I think we are as well. And I understand why they're doing it. I like Dave Marcus, her lawyer, a lot, or her current lawyer. And Todd Blanche, I got a great deal of respect for. I mean, when Todd Blanche was trying Trump's case in New York, I don't know if we did a show together when that was happening, but I was a harsh critic of that prosecution, even though ideologically I might have been on the opposite side. But I just thought Todd did a tremendous job in the faith. Can you imagine having to defend Trump in New York City at that back then? And so, yeah, and he's a former AUSA. And so I have the utmost respect for him and David as well. So I trust that they are doing what they have to do and that the fix is not in.
Moving on, I want to talk to you about Bryan Kohberger really quick. One question for you here. His appeal. Do you think he'll appeal under the Garza versus Idaho? He can. Obviously, he's going to have some flimsy support for it, but do you think he'll even do it? He has until September 3rd, I believe.
No, if I had to bet on that, I'd bet not. I just think it's, I don't think so. That whole disposition, if you want to call it that, is mind-boggling to me for a number of reasons. I don't get it. I mean, number one, I don't understand why he would enter into it. Number two, it's beyond me why the prosecutor would, absent getting some kind of allocution or cooperation. Why would you? Because I've been in the case where I would go defending somebody accused of a crime, and you want to get the capital, off the table. You want to get the death penalty. And almost always you have to offer something. And the thing you have to offer is some kind of proffer, allocution, something that would at least in this case have given the families some kind of solace, closure, explanation, anything. But all they did basically was take it off the table, and it very unsatisfying, I think, from the family standpoint, from the prosecutor. No matter what the prosecutor says, I've seen other prosecutors savage this guy, and from the defense standpoint, it's a little perplexing. Although there's a lot of people who take the position in death penalty work that just winning the death penalty is enough. That's kind of a common theme in capital defense, and so I get that as well. I can understand it from the defense standpoint. I have a lot of problems from the prosecutorial viewpoint.
I agree. I'm 100% with you on this. And I tell you what, it was a win-win-win for Bryan Kohberger, in my opinion. And I've never been a part of a case ever where we didn't work out a plea deal and I'm not sitting in jail with the guy for the next 10 days, finding out everything he did from the minute he had a memory until the crime was committed.
And by the way, speaking of Ghislaine Maxwell, I'm sure that they worked out a queen for a day, which is a temporary immunity agreement. You could do the same thing with him. You could just say, okay, we're going to agree that if you're truthful, we will take death off the table, but we're going to throw Coffindaffer in there and have her debrief you for 10 days. And by the way, you wouldn't have all the backbiting from the families, in my humble opinion, because they at that point would get some kind of solace, closure, whatever word you want out of it, in that they would have some answers, or at least they would have some of the questions asked that they wanted answered.
Yeah, I agree. We're on the same page with that one too. We're going to move on to Reed now, because Reed,
this is where we'll disagree.
Well, I don't know, because it depends on my question. I mean, your answers, right? I don't want to talk about that verdict because I'm so incensed about it that, and I think the jury, I think they were tainted, blah, blah, blah. But I'm not going to come from that angle. I'm going to come from the angle that absolutely blows my mind. And that is the fact that AlanJackson, 2 days ago, I believe it was, said, listen, now I'm going to represent her on the civil side. And I have never seen this. I mean, he had clients like Spacey, Weinstein. He's got supposedly a plate full of criminal defense work. What in the hell is he doing?
Well, I've known Alan, in full disclosure, since he was a young prosecutor. We had a case against each other that was called the Japanese OJ, where we fought like tooth and nail. When I was defense, he was the prosecutor, well before he had done the Specter case. In fact, his co-counsel was a judge, who's now a judge, the presiding judge in LA Superior Court. And Alan, I always knew was going places. I always knew that he had a bright, bright future. He was good in the courtroom. He's good on his feet. He's a good-looking kid. He talks. And by the way, he also married an Armenian girl who I think is a delight, his wife. But he knows that case so inside out. Once you try a case, not once but twice, and I've done that a handful of times over the years. In fact, I've tried a couple of cases 3 times. You become wedded to the case, to the facts, to the client. And unlike my career, you're right about the fact that he's been primarily criminal defense. He and his partner, Mark Worksman, who I've also tried shoulder to shoulder. Mark and I have tried several jury trials together. Successfully. I don't think I've ever lost a trial that I've done with Mark Worksman, his partner. They don't do as much civil. They do some civil, but there is a point in most trial lawyers' careers where they want to branch out and do some civil work for a variety of reasons. If he was ever going to do it, if he was ever going to be tempted to do it, this would be the case that I think he would. And so I get it. I mean, it's obvious he feels passionately about the client. It's obvious he knows the facts in that case. And boy, I'll tell you, he should take the bar exam in Massachusetts, because you mentioned Spacey. Between Spacey and this case, he's the go-to guy in Massachusetts.
Well, that brings up another question for you because, and I was going to play it, but we've got limited time, so I won't. Pro Hoc Vice, right? He is practicing there underneath Yannetti, right? Underneath his shingle, if you will. My question for you is, he got in a lot of trouble with Judge Cannone, and I have the clip where Judge Cannone says, lack of candor, it wasn't by accident, multiple egregious violations of Rule 14, et cetera, and this is deserving of sanctions. Now, I wasn't surprised when Reed said she wanted to keep him as her attorney, but I'm shocked that I haven't seen a bar complaint. I haven't seen anything happen out of that, despite her shaking with anger and dismay and making these findings. Mark, what can we expect, if anything?
Well, if I remember correctly, and I haven't talked to Alan about this, I remember that after she's made that statement, her being the judge, she then called Miss Reed and the defense team up to sidebar and sealed the transcript. I don't know if that's ever been unsealed. I'm going to venture to guess that the reason she did that is she asked for a waiver, and whatever she was upset about, she being the judge, she wasn't able to penetrate the attorney-client. And part of the lack of candor, and this is complete speculation, but it could have been that it came from the client and not from the lawyer, meaning the client could have been the genesis of the lack of candor. If that was the case, you can't force the lawyer to point fingers at the client. And I think she probably called them up and sealed that in order to have Karen Reed waive any kind of conflict. That's my guess. If that's the case, if what she was so upset about was work product, then you've got a hard time trying to discipline him on that. Having said that, it's interesting you bring up the issue on Pro Hoc, because there was a decision that I saw just today in the federal court in LA. I'm not in LA, but I saw the decision where Judge Wilson, in a Hunter Biden defamation lawsuit, declined to do terminating sanctions on a guy that Hunter Biden is suing, who was a client of mine, but I don't represent him in this civil case. But the judge had declined to let a lawyer come in pro hoc vice, which means with permission of the court, because this lawyer had been denied and had been found to have issues in another court. And so that is something that happens on occasion where your pro hoc is denied. And I just read about it today.
Yeah, it's interesting. I just don't understand. So just really quick, and I'm going to say it in about 30 seconds, the details of that were really in open court. AlanJackson said that he hadn't had communications with one of the witnesses. He hadn't paid one of the witnesses. And then later it came out, transcripts between the witnesses, emails back and forth, money that was paid. And it was just such an egregious lie that all of us got to witness. We got to witness it in open court. So it didn't really have to do with the client. I find it so strange that nothing has been followed up on, but I just wondered if you've ever seen that. And I wonder if his pro hoc vice will be in jeopardy, as you mentioned in the case.
Yeah, in this other case, I don't know. I wish I knew more about the facts of that. If you have me back, I'll find out, and I'll give you what my interpretation is.
Great. And one last question on Reed. AlanJackson got on national television, and all those attorneys said they worked for free. Now, you're a defense attorney with a large list of clientele, at least for sure, in your past and still current. But when you were at the prime, like I think is at the prime of his practice, and I know even now with my expert witness work, there is no way I could take off 2 weeks or 2 years and just, sorry, all my clients, you're going to have to find help elsewhere. You could never do that. How did he do that? And how can he possibly say he's doing it all for free? Help us out, Mark.
One of the great things about reaching the pinnacle of where he is that you can charge what the traffic will bear, so to speak. And and he has partners. I'd mentioned Mark Worksman, who I think the world of and have tried cases with. He's got other able partners. I remember back in the 90s, I took on a client that kind of propelled my career. And luckily I had back then, my brother and my father at the firm helping me out. So sometimes you get on one of these kind of missions, if you will. And I remember when I told my father about a case in particular, and he says, if you're not going to take her case, then why are we doing what we do? Which I thought was an interesting comment. So I would imagine that, and by the way, I've wondered as well, how is Alan getting paid for this? Because you got to pick up, you got to move. It's a ton of expenses. I've been there, done that. It's a drag. I mean, it really is a drag. But a lot of times, if you get invested in it, in the case, and you have the ability or partners who are willing to do it, then that's how you make it work.
All right, I'm going to move on to really quick. Luigi Mangione, question for you. My goodness, I mean, I know this case pretty well. It just, to me, is a slam dunker with all the evidence they found on him. They've got the gun, they've got the quote unquote manifesto, not much of a manifesto, but the clothing, the video. I mean, what in the world could possibly be? And I know it's the same.
Yeah, in full disclosure, again, his lead lawyer is Karen Agnifilo, who used to, when she left the Manhattan DA's office, came to work for me. She now is of counsel at the firm that my daughter's at, whose partner is Mark Agnifilo, who Tenny and Mark tried Diddy's case. I have said before, and I'm not talking out of school, anything they've told me. I've said before that you win or lose criminal cases in jury selection. And also, you've got to have a constituency. Your client has to have a constituency. Luigi Mangione has a constituency. For better or for worse, there are people who support him. And, they always say there's a raging argument for 250 years, is jury nullification a proper or improper constitutionally? I take the position that it's proper constitutionally, because that's what makes America great. Is there the possibility that he could get a hung jury in this case? I think it's more than a possibility.
Yeah, if he gets a bunch of 20-year-olds on that jury, and not a bunch
you said it, not me.
60-year-old men. I mean, that's what I would be there.
You don't want a bunch of old white guys like me, right?
No. All right, two more. Menendez. I know this, he's your client. They are your clients. This is something, obviously, I've had strong viewpoints on this, but
tell me about it. What bugs you about it? Because I embrace the dialogue about it, because I don't know. I mean, I remember when the case was happening in real time. And one of the things that bugged me about it, I tried a case in the 90s, right? I don't remember the exact time, but I remember the client's name, Yoshi Kale. And we used the battered woman syndrome, BWS, for Yoshi. And she was charged with first-degree murder. We eventually, after trial and after going up and down, I got her a voluntary manslaughter and probation. And it always struck me that Yoshi got a manslaughter, probation, was freed, actually collected, believe it or not, life insurance. Her husband was a life insurance executive. And that the brothers weren't able to avail themselves of that in trial number 2. I thought that was unfair. And the more that I get into the case, I think they got the pendulum swing, because their second trial started taking evidence 8 days after OJ was acquitted. And I've had this discussion with Marcia Clark, because Marcia was a hard charging prosecutor back then. who I knew well before OJ and knew her mentor well before OJ. And we used to say, unless you understand Los Angeles in the 90s, and unless you understand that LA DA's office in the 90s, you don't understand what happened to the brothers. And that, I think, is an explanation for how they got convicted. And then fast forward, I've been to RJ Donovan not once, but twice, maybe 3 times. I watched Lyle graduate from that first inaugural UC Irvine collaboration ceremony and get his bachelor's degree. And now subsequently, Eric has graduated as well. I've seen the Green Space program presentation and everything that they're doing on there. And I've talked extensively with Eric about the hospice program that he's instituted. And, the hospice program, if you don't understand California, back in the 90s, we were locking up everybody. And a whole generation was locked up. You go down to the prisons now, and it's jarring to see the aged out inmates. I mean, you got more than your share of wheelchairs, guys who look, who look like they're on their last legs. I mean, it's hard to believe. It looks like a geriatric community. And the hospice program that Eric has developed is really, I think, life-changing. And so they've done such good work. I don't understand at this point. They aren't who they were. They didn't get, trial number 1, they had Leslie Abramson. They got to put on their defense, and more than half of 2 separate juries found them not guilty of murder. And so I defer to them. That's my soapbox, and that's my opinion.
Yeah, for me, I just cannot get past the threshold of that they were molested by their father. I can't get past it with all the facts I know. Having said that, even if they would come forward, as I've already, Lyle Menendez basically did himself in with all of his admissions before trial 2. If they would just be honest, I think about all of that. I think so many more people could get behind them. In other words, honest that is not the case. Because I don't think it's the case. I think
I get that people find it hard to believe. I mean, I get that. The fact is that we have evolved, and there are. I mean, it's an unfortunate, dirty secret, if you will, and it happens. And there are so many things when you take a granular view of the evidence that was so compelling in the persuasion of more than half of the jurors. And by the way, if you look at the records, it broke down in trial number 1 almost exclusively along gender lines amongst the jurors. The women all believed, the men all did not. It's wild to me, but goes back to my theory that we talked about when I started. You win or lose your case in jury selection. So,
yeah, you sure do. And so really quick, because they now are sentenced to 50 years and eligible for parole, what is when do they go before the hearing board? What's happening?
So literally 2 weeks from today is the first parole hearing. 2 weeks from tomorrow, and I always forget who goes first, is the other parole hearing. So 2 weeks from today and tomorrow, today being the 7th. And this week, also, the DA's office was ordered formally to respond to the habeas corpus. So the DA will be filing their reply to the habeas corpus. So we've got 3 different tracks. We've got the parole hearing in 2 weeks. We have the habeas, which is now formally they've been ordered to respond to. And we have the governor, who has got the ability to commute their sentences. So we've gone from 2 years ago when Cliff Gardner and I decided to file this first habeas, from a long shot to now we've got a real shot.
And really quick, Mark, what is your answer to many of us that would say, even if they were abused, look at what they did to the parents. Kitty on the ground, hunting her down, going back, reloading, the premeditation of it all. Obviously, this wasn't self-defense. The multiple different offerings of what happened that night help us understand why somebody who can commit that heinous of an act deserves to be released.
So the question is, was not self-defense. Leslie Abramson, who was the lawyer for Eric, conceded that. It was imperfect self-defense. And by the way, once again, the jury, two separate juries who heard that in trial number one, half of them agreed, number one. Number two, the law is clear in California. Even in the most heinous crime, and by the way, half of the jurors felt that it was manslaughter, not murder. Jurors who sat there for months on end listening to the evidence. The law in California is you look at their record for 35 years. Of that 35 years, since 2005 up until about 2023, so 18 years, they had no hope. They had no appeal going. They had no habeas going, nothing. During that 18 years is when they transformed themselves. They had a kind of a fork in the road, and they took the right turn, if you will, meaning they decided they were going to do good work. And I always point out, especially to people who are pro-law enforcement, who supports this idea of resentencing and giving those who have been sentenced to life without, who some of the biggest supporters are? Law enforcement, correctional officers, because it gives the inmates a reason to behave and a reason to work on themselves. And it's healthy for correctional officers to be in an environment where you don't have people who feel like they've got no hope, nothing to lose, and you have to constantly look over your shoulder. So that would be my answer to it. And I've given you 17 minutes more than my heart out said.
All right. Well, the only one we didn't get to was Peterson. I hope that someday we can reconvene. I do not want to take up any more of your time. If I were in trouble or had a relative in trouble, I would be calling you nonstop. I think you're brilliant, and I thank you for your time.
I appreciate that. You keep saying that, and I'll take it pro bono, just like Alan.
All the best. Thank you. Thank you so much.
That was fun. Thank you. Bring me back anytime you want to talk, Peterson.
Thank you.
Bye-bye.
Oh, gosh, guys, that was so great. Been on different programs and shows. Obviously, was on Cuomo for about a year or more, usually side by side with Mark Geragos. And that's where you really get to interact. And it was always interesting. They would bring me on right from the side of sort of obviously the prosecution side, the law enforcement side, that lens. And he was always on the other side, right? Defending individuals and looking out for their rights and doing it brilliantly. And anytime we were on a show together, whether it was no matter what the show was, no matter what the topic, sometimes you just get on these shows with people and you just click, you just, understand each other's point of views and have that, karma together. I don't know what to call it. And that's how I always felt with Mark when I met him in person, the same thing. And I like to see things from other people's views. It's just really important. I think no matter what, to keep one's eyes open. He pointed out some things that I'm going to be thinking about. And I so appreciate all of you that were able to join us because I think it's a rare treat to be able to intersect with and hear from somebody that is as knowledgeable, experienced, and has had the opportunity to defend some of the most prolific individuals and cases that we all know about. So anyway, I'm glad you were all here. I hope you enjoyed the show. And, I'm grateful he was able to come on. I really enjoyed that. And I hope until next time that justice will be served. I look forward to reading all of your comments since we have some extra time today. And I will type back the answers, or if I know them, or comments. So everyone, thank you and have a great evening.